Sorry, are you all set? Okay. Good morning, everybody. Thank you for coming to Free Pastry Friday. We are closing in on the end of the lectures on copyright and trademark. Next week, I'm going to get into patent law technology, and I think I told you I'm going to tell you the story of graphene. I want to focus for those 2 weeks on actually patenting a device. And by the time you walk out of here, you'll be able to, at least you won't be afraid of patents. And hopefully you'll be able to protect that intellectual property that you come up with that qualifies for utility or a design patent. But before I get into patents next week, I want to kind of finish up on copyright and trademark. There's so much I can go into. You can literally teach 12 weeks on just one of these things. But before I do, I wanted to get to a couple of the questions that were raised. Again, I've passed out the obligatory questionnaire. Please keep your questions coming. I've been getting emails from you. Some people, like me, actually write things out on paper, but I really find them useful because I think that it helps all of us learn. Like I said, learning is like a blockchain. Every question is a block in the chain, and eventually we have real education here. So that's why I treat your questions first when we start a class, because I think there's nothing more important than your questions. The first question we have is, if you believe you have a valuable idea, how do you claim it as soon as possible? Who can help me out with an answer to that question? Yes, sir.
So, if you should write it down somewhere. Make sure that you got to have it somewhere.
I think you've been to 2 classes, but you certainly have internalized the message for the 2 classes you attended. Exactly. Like any answer in the law, the actual answer to this question is, it depends. But the general principle that you're articulating is exactly right. You have to express it in some tangible form. And what I mean by it depends is it depends on what type of an idea you have. Is your idea about a new device that would qualify for a utility patent? In which case, you have to describe it in some way, and as we'll find out next week, you have to file a preliminary patent application in order to protect it. Because we're in a first-to-file country now, if your idea is about something that qualifies for a patent of some type, either a design or utility or an animal patent or a plant patent, then it doesn't do any good to write it down in a notebook someplace. That was the old days, as the people in the CRISPR case found out, as the people at the Broad Center and UC Berkeley found out. Writing it down in a notebook doesn't help. What you got to do is you've got to win the race to the steps of the United States Patent and Trademark Office. You have an idea that qualifies for a patent, file a preliminary patent application. Keep it to yourself until then. If you discuss it with anybody, what do you have them sign? NDA. A lot of people don't even know what NDA stands for. Non-disclosure agreement, exactly. Get that on a piece of paper. Okay, very important. Treat it as a secret.
So we just said that writing it down is very important. But
yes.
Then it doesn't matter because it's first.
Right, and that's why I say the answer to the question is it depends. If it is something that qualifies for patent technology, then you've got to write it down on an application for a preliminary patent to the USPTO. If it's a song, how do you protect it? Well, write it down. Remember, as soon as you put your pen on the paper, a copyright is established. So if it's a book, if it's a paper, a PhD thesis, if it's a text, if it's a piece of software, as soon as you hit save on your computer, then it is fixed in a tangible form and protectable. So if it qualifies for patent or trademark technology, writing it down as quickly as possible, creates, establishes your right. As soon as you convert it from an idea into a tangible form, it's fixed and it's protected, and you have rights to it. Now, you can also go to the additional step of copyrighting it with the USPTO or trademarking it with the USPTO. That's very useful if you want to enforce those rights later on, especially as against an infringer. But it doesn't change the fact that you have those rights. As soon as you hit save on that computer, it's fixed in a tangible form and it's yours, at least for 70 years plus your lifetime. Okay. Next question, can you give examples of tangible forms of intellectual property? Well, come on.
Piece of paper, written.
With something on it, right? Presumably with something on it. Yes. Excellent example of a fixed tangible form.
Computer file?
A computer file. Excellent. And the courts say that anything recorded just on RAM will qualify. So, which is interesting. So as long as it's sitting on your screen, okay, you don't have to even download it to a file or anything like that. As long as it's sitting on your screen, it's considered a fixed intangible form and you own it for the next 70 years. Anything else? Can you think of examples of intellectual property?
Logos.
Logos, exactly. Photographs, graphic depictions of any kind, Daffy Duck, Donald Duck, whoever it was that we were talking about there. Examples of intellectual property, the windshield wipers on your car, the design of this chair was probably at some point subject to a design patent. The Nike swoosh, okay, those are examples of tangible forms of intellectual property. Anything that can be expressed in tangible form is protectable. As long as it's inchoate, though, as long as it's in your head, it's not protectable.
A recording that works.
Any recording is sufficient, but to prove it in court, it's got to work. So a recording something, if you were to speak into a microphone and record it on, digitally or on a tape recorder, that's a tangible form. You save it electronically, save it in some analog way, any way it's saved or preserved probably, definitely qualifies as tangible expression of that idea, and it's protectable. Okay, the thing I wanted to talk about today, I told you yesterday, is fair use. Does anybody have any idea what fair use is?
Public domain?
It's similar to public domain, but it's different. Okay. Does anybody get their news? Let me find out if the polls are true. Does anybody get their news from The Daily Show? Nobody gets their news from The Daily Show. I guess that's some other generation. Does anybody watch TV? We have one person that's watched TV here. That's excellent. I'm up here yesterday talking about, how my parents owned a Dumont with 3 channels. And now we have one person in the room that watches TV. I've completely been bypassed. This is great news. Thanks for making me feel so old. Can you give me an example of fair use? When I say fair use, what is it? What's the common sense definition that pops into your head?
Would it be something well, the news are here when you're teaching, you can show a logo and it doesn't matter, you can use something like that in your...
It's something that is fair and used, right? Sure. So it's an example of intellectual property. We talked about how intellectual property rights give you exclusive rights to that item. So if you own a copyright, you own it for 70 years. If you have a patent, it's 20 years. If you have a fancy logo, as we talked about, it's yours through infinity as long as you keep renewing it and using it in commerce. But that's a lie, because you don't have exclusive use to it. There are some times when others can use your intellectual property and not have to pay you for it. Okay? There are certain circumstances, certain exceptions to intellectual property law and the rights that are protected that give people the right also to copy what you've done, even though they don't pay you for it. Okay? There's a famous old saying, a picture is worth 1,000 words. Actually, I think the expression was by Fred Barnard, a picture is worth 10,000 words. I think that's the exact quote. But you've heard that expression when it comes to graphic depictions. You know, a photograph. A photograph, by the way, is an example of intellectual property. So, I mean, everybody's heard that expression, but there's an old joke in the intellectual property world that I live in that goes, picture is worth 1,000 words, but 3 words you don't want to hear are cease and desist. Those are 3 words that apply to intellectual property that you don't want to hear. Does anybody know what a cease and desist is? What does that mean?
You have to stop using whatever you're doing.
Exactly. You get a little letter in the mail that says, "Dear sir, it's come to my attention that you're using something that I have copyrighted. Please cease and desist all such use, or we will sue you." Okay, so 3 words you don't want to hear in intellectual property law are cease and desist. And the question is, when do you hear those words? So in the United States copyright law, fair use is a doctrine that permits limited use of copyrighted material without having to pay somebody to use it. And it's a copyright principle based upon the concept of knowledge and ideas have to be freely shared. We talked about the balancing test that we do as a society. How much do we allow people to silo information and knowledge and inventiveness? And how much do we require them to disseminate for the benefit of society? What was your question? Teaching can be an example of fair use? You're a couple of slides ahead of me, but that's exactly one example of fair use. Exactly. So there are certain ways, certain things that we've developed under the law that establish what is and what is not fair use. Whether you will get a cease and desist order that you have to comply with, or whether you don't have to comply with a request for a cease and desist. And it's under Section 107 of the copyright law. Fair use is all about that delicate balance between the rights of the creator and society's right to use that information in some usually non-commercial way. And when in conflict, the balance usually goes to society's right to use it. So here are some examples of fair use. Social commentary or satire, commentary about politicians, commentary about public figures, search engines. You know, what would Google do without fair use, right? Criticism, you know, the president of MIT is a fink, you know. Parody, I mean, that's pretty self-evident. I don't think you can swing a dead cat nowadays, especially in this political climate, without running into some sort of political parody or satire or commentary. News reporting. Have you ever noticed that, you know, can you imagine the sports? When you turn on, when the one person that has a television here turns on the TV and watches the sports, can you imagine watching sports? Or can you imagine ESPN even existing if they weren't able to take content from broadcasters of sporting events and share it? Okay? It's a sort of a complicated set of laws that involve that sort of commercial fair use, but commercial fair use is often possible. Of course, that's why you only see little snippets of 14 seconds or less. News. You know, can you imagine not being able to go down and film a news story because somebody's logo is in it or somebody's invention is in it? Of course it gets to be used. Teaching. How many slides have I stolen off the internet and put up there in front of you in the last 4 weeks? I'd be out of business if it wasn't for fair use, or worse. Library, archiving, and scholarship. What would a library be how could a library exist if they couldn't, take copyrighted materials, put it on their shelves, and disseminate it publicly? Okay?
So there was a movie called Super Size Me. It's about McDonald's, right?
Yeah.
So the whole movie was about
Some guy ate that stuff for a long time and,
right.
turned green, whatever.
It's totally legal to show McDonald's, the logo, everything.
Absolutely. One of the biggest uses of fair use is in reviews. Does anybody, what's that web service that, you go on, you say I had a terrible meal at Yelp? Exactly, Yelp. Can you imagine if you sat down and said, gee, I had a rotten steak at Outback Steakhouse last night. Their bloomin' onions are not as good as they say they are. And then you get sued. Okay? Why don't you get sued? Why can't Outback Steakhouse come after you and say, you're using our logo, using our name? In fact, you might even put a picture of the Outback Steakhouse that poisoned you, up on your site, up on some website. How come you're not sued? That's why. Fair use. Fair use. That's why if they send you, if the lawyers for Outback Steakhouse send you a cease and desist letter, you write them a nasty letter back saying, sorry guys, this is fair use. Okay? I can say anything I want about your steaks that still have the marks where the jockeys were whipping them. All right? That's fair use. Okay. It's a doctrine that permits limited use of copyright material, and it's subject to certain limitations under Section 107 of the Copyright Act. And so I already talked about the balancing test. Basically, it comes down to whether or not something is a criticism, a satire, a comment, a report, a teaching, anything that adds context to something, or reports it. All right, so the factors to be considered when you get accused of violating someone's copyright or trademark or patent, and your defense is, well, sorry, it's fair use. These are the factors that the court will consider when deciding whether or not you're liable for infringement. First of all, it's the purpose and character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. I can tell you for a fact that when I stand up in front of you here lecturing, it's a nonprofit activity. So I come under Section 1 of Section 107, subsection 1. The nature of the copyrighted work, it depends upon what you're using. And I can get into some examples of it. It's easier to show you some slides about that. The amount and substantiality of the portion used in relation to the copyright work. And I can get into some examples of that. But how closely does your use of a particular mark or copyrighted material resemble the original? And I'll give you some examples. And the effect of the use upon the potential market for the value of the copyrighted act. Well, if Outback goes out of business because you have uploaded, some comments about how tough their steaks are, that's tough for Outback. Usually, that last subsection has to do with how close to the line between interfering with their market you come. And we'll get into some examples of it. These factors are weighed in each case to determine whether a use qualifies as fair use. And the distinction between what is fair and what is infringement in a particular case will not always be clear. Yes, sir. Brian.
All right, so I have a question as it relates to the use of journal literature articles. So if you get something from one of, Elsevier or something, you have to pay to use it. What if the same content is then found on a government-produced report, which are generally open to the public? Which one takes precedence?
First one. If you're using it privately, then you've got to, generally speaking, pay the rights holder. The fact that the government happens to be using it, it's okay oftentimes for the government to be using it, but that does not inure to your benefit.
If the content of the published paper is also seen in a government-produced report.
Well, then what's the answer to that legal question?
The first one.
It depends, okay? That's the answer to every legal question. But I would have to know more about it. Is it if it was initially published by the government, or in some circumstances when it's published by the government, it could come into the public domain. So we're not talking about fair use in that case. We're talking about republication of something that is in the public domain. It would depend upon the circumstances of its republication by the government and the terms under which the government has republished it. For instance, if it's statistics, something published by the Center for Disease Control, that's probably public domain that you're talking about. So you can cut and paste that chart and put it into your paper. If you get nervous about it, you can attribute it. So cite the source. That doesn't necessarily cure an infringement, but it might make everybody feel better. And also you can change it. Remember, we talked about the novelty requirement. So if the CDC has some sort of graphic depiction of some data, and you superimposed another set of data points, then you've changed it, and now you set aside the originality of content requirement. So there's like I said, it depends is the answer to most of these questions. As my slide says, there is no specific number of words, lines, or notes that may safely be taken without permission. So in almost every case, that's basically the embodiment of that legal tenet that I've tried to talk about, which is it depends.
You earlier said 14 seconds for a video clip. Is that a standard, or is that just?
Yeah, no, that's for some. Again, there's a whole complex area of law that deals with, rights and fair use when it comes to various video broadcast rights. But one of them that sticks in my memory is 14 seconds. That's as much as you can show. You go past that, then you have to start paying the broadcast rights owner. And these terms often change too. But 14 seconds is what I recall, which has to do with the rebroadcasting of certain things that are broadcast on television. Unfortunately, weighing the fair use factors is often a very subjective process, and so the fair use roadmap can be a little tricky to navigate. So I have some examples of fair use. Somebody took that photograph and owns the right to that photograph. They copyright it, own it for 70 years plus their life, right? This is a tangible expression, okay, of intellectual property, and it's protectable under the copyright law. Anybody see any similarity between the two? Of course. But why is this okay to do? What did we just talk about? Well, first of all, do you see any difference between the two?
Yeah.
Okay? One is a more stylized version of the copyrighted material, right? So it's changed a little bit. Remember, we talked about, whether or not you capture the entire image. Yes? Somebody was,
Different message.
different message. And what kind of message is it?
Right, left one.
I would say it's a political message of some sort, right? So this protected piece of intellectual property is being used to convey a political message. And that's right down the, you know, the middle of the road when it comes to fair use. That's fair use if I've ever seen it. Yes, sir.
So you go back, so the person who took that picture,
Yes.
right now, he owns that picture. What about the person on the picture?
Well, the person in the picture, many of you may recognize. We call them public figures. And oftentimes, public figures do not have control over their images. A photograph of you, used for commercial purposes, probably is infringing or could be considered an invasion of your privacy. But public figures don't have the same privacy rights as you and I have. So I can take an image. If I'm the photographer, I can take President Obama's image and exploit it commercially because he's a public figure. I probably couldn't do the same thing with your image, as handsome an image as it is.
So I have a follow-up question. So when you can say, okay, this guy is a public, like I can take a good teacher, good professor like you, and you public figure.
I'm not as much of a public figure as this guy, but I'm probably more of a public figure than someone walking down the street. And so the answer to your question is exactly. Depends on the circumstances, and it really it's basically a reasonable man test. Okay, there are court cases that define what a public figure is, but it's squishy. I can tell you, having read them all, it's squishy. That's a public figure. After that, I can't really be absolutely certain. Okay?
So with the Marilyn Monroe picture is a
Great example. Great example. Great example. Her estate owns the rights to her image. So if you want to use Marilyn Monroe's image in a commercial way, what do you have to do? Have to call up the Marilyn Monroe Estate Foundation, go on their website, pay the fee, and download it.
What about that famous Andy Warhol?
Well, what about it?
Did he pay?
What did it look like? Was it Marilyn Monroe's image?
Yes.
Well, it was a stylized version. It was an artistic interpretation, very much the same as this. And that would probably, and now painters and sculptors and artists are also considered political commentators. They're trying to evoke some sort of feeling in you. They're trying to convey or express an idea. And when it comes to expression of ideas, the law usually comes down on the side of expression. So, you know, if I wanted to take the picture of the president and draw a mustache on it, and, you know, I could do that. I could take that image and I could change it in order to convey a political or social comment. Same with Marilyn Monroe. Again, you know, but if I want to use her image in a movie, probably not. You know, I'm probably going to have to pay the foundation for that. So again, the answer is it depends. The Mona Lisa. I mean, this is the Mona Lisa with a, I don't know if you can see it, but with some additions to Leonardo's original work. Perfectly appropriate. The artist in this particular case was, you know, taking an image from a book, or maybe the original, I don't know, and changing it. Now, what wouldn't be fair use? What if I decided to do a book of art and sell it as a coffee table book? And I took the Mona Lisa's image, a copyrighted image of it. Would that be fair use? The Louvre very well may come after me, or more likely the people that control the image that own it. And again, am I using the whole image? Am I using just a part of it? You know, the answer is oftentimes it depends. How much of the image are you stealing? Are you copying? Yes, sir.
Back to what you're talking about with film. Where do we draw the line between a film like a documentary as a social commentary or some political commentary versus a commercial enterprise?
Well, it depends on on the content. Of course, if you produce a film that has, you know, the object of which is political commentary or any kind of, for any reason at all, any artistic expression, as soon as you put that in the can, as they say in Hollywood, as soon as it's preserved, it belongs to you. It's a copyright. So that belongs to you. Okay? Now, if you use certain content in the film, depending upon how it's used, Michael Moore does a lot of films, does a lot of political sort of commentary. And he'll often use images that in other contexts would be protected or copyrighted. And he's able to use those because it's fair use. Why? Why is Michael Moore able to go out and make fun of General Motors for building cars that either fall apart or kill people? Why is he able to go out there and film the Exxon, or some other environmental, polluter? Social commentary, political commentary. He can put that movie and put that film in the movie houses and sell tickets to it. It's okay. Okay. But again, depends on the content. Anyhow, Mona Lisa, the cat in the hat, the cat not in the hat. Okay, this kind of gets to your question. Copyrighted image owned by Dr. Seuss and the Seuss Foundation. Well, they're not immune to commentary. If somebody wants to trade off of their name to in this particular case, do a parody, it's permitted, fair use. Anybody recognize this character? The reason I put this up is because I was scrolling through my social media feed last night, and some knucklehead on my feed has taken their picture, it's where their picture used to be, and now they have this picture on there instead. And actually, yeah, Alfred E. Neuman. Do you know what the E stands for in Alfred E. Neumann? Enigma. I don't know why I know that. But anyhow, they had this picture instead of, this is on their Facebook post. They allowed to do that? This is a trademark of a $50 million corporation. Can they do that? The answer is, of course they can do that, because they're not trying to profit off it, that it's not a commercial use. They might be saying something about themselves, so they can borrow that image. Now, if I wanted to start a magazine, a satirical magazine, could I use that image without paying for it? Well, the answer is, of course not. And do you think the people at Mad Magazine would let me publish something with their image on it? So the question is, should he worry? Okay, that's the famous saying associated with Alfred E. Neumann. Well, should Mad Magazine worry? Do you recognize who that is? Right? Political commentary, satire, perfectly appropriate use. I was just having fun with some of this stuff, showing how many images I could steal off of the internet. Who's that? Is that Prince Charles, or is that Tony? I don't even know who that is. We were talking about rights to movies. Well, here's Mad Magazine. They have stolen Jabba the Hutt. You know, Lucas Enterprises owns Jabba the Hutt. I dare you to go out there and start a Jabba the Hutt restaurant. Not going to happen. You're going to get one of those letters that contain the 3 words. What are the 3 words? Exactly. But Mad Magazine can do it. They don't have to cease and desist. Why? Commentary, political satire, humor. Humor is protectable. We actually, the laws have decided that humor is important for society. And so we say that for humor's sake, you can steal someone's intellectual property, and it's not stealing. All right. Something that you probably will encounter, and something I think I really need to cover is online images. The classic use of, or example of fair use of an online image is product reviews. We already talked about that, like Yelp and stuff like that. If you want to review a book, a new piece of technology, a food product, or anything else, you'll likely want to include a photo. Some people were talking about how in their job they're doing that these days, right, Yana? Anyhow, so you head to the manufacturer's website, right? And you right-click, and you take the image down. Since a photo will not substitute for the actual product, the owner's rights should be very minimally affected. Okay, so if you're taking an image off of the web, you're probably, for these purposes, not interfering with their market. You're not competing with them, so it's probably falls into fair use. So your rights to the copyrighted image are probably protected. That brings me to the Digital Millennium Copyright Act, DMCA for short. This is something that you're probably all encountering today, whether you know it or not. But the DMCA is basically a law that was passed in the United States which codifies some treaties that have been, well, basically joined by almost everyone in the world. In the United States, it took until 1996. The rest of the world was doing it before us. But it criminalizes the production and dissemination of technology, devices, or services intended to circumvent measures that control access to copyrighted works, commonly known as digital rights management. It also criminalizes the act of circumventing an access control, whether or not there is actual infringement of the Copyright Act. Can anybody think of a platform that this applies to? This I know you watch every day. I guarantee it. Even if only one of you has a TV, everybody has a computer, and I guarantee every one of you go to it every day. Where's the last platform you went to view a video of anything? Bingo. Exactly. Why isn't YouTube sued for putting, or Facebook, or any of these platforms that encourage people to upload content? And it's not just videos and photographs. It's papers and all kinds of intellectual property. Why hasn't YouTube been closed down? Well, because it protects sites like Facebook and YouTube, where users are encouraged to upload content, by providing them with immunity. My office did a whole series of cases involving, you ever hear of the back page? I know none of you have heard of the back page, but it's kind of like it's like a Craigslist, or it's a place where people go to share content. And there was a movement that was trying to shut down the back page. They usually, they promote escort services and things like that, massages, both legitimate and non-legitimate type things, activities that are legal and activities that, despite what the site says, are illegal. And what they tried to do to shut all these services down is they sued the back page. They say you're a content provider, and the back page says we don't control what people upload on our sites to do. We charge them a fee, they upload whatever they want. We're not promoting criminal behavior, but they tried to shut the back page down because of a complaint that it was promoting content that was not always legal. Well, Backpage can't be sued because of this law that immunizes them. One of the biggest features of the Digital Millennial Copyright Act is it immunizes platforms such as YouTube and Facebook and other platforms from liability.
How about Pirate Bay?
I don't even know what that is.
Pirate Bay is a site where you can use torrent to download softwares. And
Okay, sure. Oh, Pirate Bay. Okay, all right. Well, under the Digital Millennial Copyright Act, Pirate Bay as the platform is probably not liable. They're immunized under certain circumstances. But heaven help the people that upload material to that site that don't own the content of what they're uploading. And I'll explain what I mean. So any business that allows the uploading of content needs to have the DMCA compliance language in its terms of use or privacy policy. So if Pirate Bay has that language in their privacy policy or on their website, then they come within the DMCA, okay? And the DMCA was originally limited to service providers like AOL, but they've expanded it to YouTube and Facebook and everybody else. The content provider cannot upload, edit, or crop or change the content in any way, or they lose their immunity. So if you upload some software to Pirate Bay and I change it in any way, I lose my immunity. If I don't have the language on the disclaimer language on my website in some way under the privacy or the displayed in some way, I lose my immunity. So if you own a platform like this, it behooves you to comply with the terms of the DMCA. And before a user may upload content to sites like these, they must state or say that they own or have permission from the copyright owner to upload. Yes, sir.
So if I see an image of myself on YouTube that I don't like, I ask you to take that down.
Well, it depends on whether you own the rights. As a non-public figure, let's think of a different example. Let's say you came up with some software, and you found it on Pirate Bay, and whoever uploaded it to Pirate Bay did not own the rights to it. Then what you do is you write Pirate Bay what's called a takedown letter. And heaven help Pirate Bay if they haven't complied with the DMCA, because you can also sue Pirate Bay for infringement. So not only is the person that stole your intellectual property liable to you for infringement, but if the platform on which it's being broadcast or displayed has not complied with the DMCA, then they are also liable, okay? And you can stop it. And I'll show you, this is how you stop it. Brian, yeah.
Is this why Google recently changed their policy on downloading images?
That's exactly why they recently changed their policy. Exactly. It's, Google being, terribly important to the, platform sharing department. Yeah. And basically, the whole industry follows their lead. So somebody has your content displayed on Pirate Bay or on YouTube or on Facebook, and you don't like it. It infringes on some right you have, but since this is an intellectual property course, let's say it infringes on an intellectual property right that you have. It may also infringe on privacy rights and other rights that you have, but let's just stick with intellectual property until we've mastered that. So what do? You send them a takedown letter. Now under the DMCA, what you have to do is you literally send them a letter, and it has to contain the following: the electronic or physical signature of the copyright owner, okay, so your identity, identification of the copyrighted work, okay, a description of and a link to the infringing content, the owner's name and contact information, and a sworn statement that you are the content owner. Eliminate any one of those, and your takedown letter is insufficient, and the platform has no obligation to take it down. So, but if you want to put a stop to it, that's what you have to do. Once the notice is received, the site must take down the allegedly infringing content and notify the party who posted it that they're infringing. And the party that uploaded the content may then file a counter notice that says, you don't own it, I own it. And then you're off to the races. Okay? If the people asserting the property right really don't have a property right interest in it, then the platform can continue to display it and you're not entitled to a takedown. So just finishing up here, things that you need to think about when considering whether to use a copyrighted image. Because a lot of you have asked me this question. Do you understand the term fair use? Just because you provide attribution or a link back to the original doesn't mean you're free and clear. Fair use has nothing to do with attribution. That's an issue related to plagiarism, but sometimes it ameliorates the situation. Fair use basically means that you're allowed to infringe on someone's copyright and they can't do anything about it. But if your use is covered by fair use, you don't have to provide any attribution in any way. Things to think about. Why are you using the image? Is it a commercial use? In which case you may be getting close to infringement. Is it political commentary, satire, or humor? Well, in that case, you're probably safe. Is it safe? For me, yes. For me, it's safe because I'm using this stuff for teaching purposes. And if you're just using the image to enhance a post, then, or a paper, everything looks better with graphics these days. I'm always publishing papers, and I'm always tempted to steal some image, which I never do. I join this Shutter, whatever it's called, and for like $10 a month I can use all the images I want. But all the content on the papers that I publish, in order to attract people's attention, I pay for. If you're just throwing it in there to attract attention and you don't pay for it, watch out. You could end up getting a cease and desist order. Last couple of things. Have you changed the image? Obama, Marilyn Monroe. If the new work which incorporates the copyright image is transformative, and we talked about originality of content and novelty of the image, you're probably not infringing. Are you taking an image and incorporating it into an infographic? Is the image now part of a video used for one of the reasons set forth in the Copyright Act? In the latter two cases, you may be in trouble. You've got to be really careful. Using content without changing it in order to include in an infographic or a movie, you've got to think that through. You've got to look at what you're doing. These are just things that you need to consider when you're downloading or using a copyrighted image. How much of the image are you using? If you're putting up Alfred E. Newman, that's probably okay, but if you include the words "what me worry," which is the entire logo, you're coming closer to infringement. If you're using a thumbnail and linking to the original location, there's a greater likelihood of finding fair use than just uploading the image yourself, because it's not fixed. So if you just, if you use Wikipedia, you click on the link, that's why it's fair use, okay? Without those little blue things that you click on, closer to infringement. If you're doing a post about facial features and are just using a portion of the face, this much, you're probably not infringing. So it depends on what you're uploading. It depends on what it looks like. It depends on the image and the circumstances. There's a million other things I can tell you about copyright. I wanted to get into blockchain technology and how that's changing copyright forever. The whole world of intellectual property is going to be changed by blockchain technology. In a few years, we're going to be uploading all of our patents and copyrights and all of our music to blockchain networks. Hundreds of thousands of songs are already now being used via blockchain technology. there's a dozen, Spotify, UMusic. There's a million sites out there now where artists are literally contracting directly with the users and eliminating the middleman. It's the best way to license products now. And these services not only get the artist paid directly, but they also search the internet for infringers. Using smart contracts, now you're going to be able to just click on a button and access music. In the future, that's how all music is going to be disseminated. So we're entering a new age as technology grows and changes and becomes more sophisticated. The law of intellectual property changes with it, and there are more efficient and cost-effective and effective ways of enforcing intellectual property rights coming down the pike, starting with blockchain technology. And I wish I could go into all that with you, but next week we're going to do patents. I'm going to tell you the story of graphene, and we're going to patent our own thing, okay? You'll walk out of here knowing how to patent your own thing. Yes, sir?
Citation. So I thought as long as you cited the source that you were okay.
No. So you learn one good thing. You're safe from plagiarism, but you're not safe from copyright infringement. Well, good. Somebody learned something in the course. I feel much better, all right? All right, everybody, see you, I think next week I'm Wednesday and Friday. You'll have to look on the thing, but definitely Friday. And thanks for your questions. Keep them coming. The little surveys that I gave you, you can bring them next time. You can